The prohibition of government abridgment of freedom of thought is among the strictest of First Amendment protections. Unlike abridgment of speech or expression, where this court permits limited exceptions, it has firmly stated that there is no justification that permits the government to enter the private, sacred, and intimate realm of unexpressed human thought and emotion to either create or use as a premise for criminal legislation. The barrier prohibiting such intrusion is absolute and impenetrable. This court has interpreted this prohibition in two distinct ways, both of which were alleged. First, on multiple occasions, this court has found that the First Amendment strictly prohibits any consideration, investigation, or probing into personal thoughts to create criminal legislation or otherwise deny freedoms, privileges, or benefits. Government actions counter thereto, regardless of any offered justification, are unconstitutional. And then I quote some cases that were beautiful and relevant. The first one is Spicer v. Randall. And the United States Supreme Court says in that case, what one thinks or believes has full protection of the First Amendment is only his actions the government may examine and penalize. The next one, Schneider v. Smith. The First Amendment's ban against Congress abridging freedom of speech creates a preserve where the views of the individual are made inviolate. And then Baird v. State Bar of Arizona. Whatever justification may be offered, a state may not inquire about a man's views or associations solely for the purpose of withholding a right or benefit because of what he believes. Here I stated a plausible claim for relief that respondents' actions are constitutionally prohibited and thus violate the First Amendment. Specifically, I set forth numerous facts alleging the following. 1. The government and UN created an entire investigation protocol to identify and predict thoughts, moods, desires, and emotions that might arise in individuals surrounding the consumption of a particular substance. 2. They have used and continue to use this investigation protocol for every drug evaluation under both the CSA and conventions. 3. The findings produced pursuant to these unlawful investigations are used to determine whether the private harmless conduct of possession will be criminalized. 4. These investigation protocols and findings serve as the primary and foundational basis for the resulting scheduling decisions and criminalization of private possession. It is further worth noting that in my complaint, I quoted direct statements that I found in government documents used to determine when personal possession of substances will be criminalized, wherein the government explicitly references specific thoughts, feelings, and desires it identifies as unfavorable for us. Such statements should never be found in documents relied upon to create criminal legislation, and their mere existence in government records should suffice to raise a plausible claim under the First Amendment.